testing the House Leader of the third party.
Thank you, and thank you for this opportunity to ask the Minister of Indigenous Relations and Reconciliation. Normally, first out of the gate would be a member of the official opposition. I have been working with my colleague from, I think it's Vancouver-Langara, and I've got the first hour or so of questions. The member will be taking over from there. So appreciate the extensive introduction to this budget estimate from the minister. Appreciate the journey that we're walking towards on a reconciliatory journey that we're walking together here, and recognize the investments that the government has made, the relationships, the legislation that's been put on the table, and the spirit of my questions today they're going to be they're I think pretty heavy stuff that I want to go through. I think that it is not the content that I'm going to be covering is not to, I think, ignore the fact that there's a lot of good things happening, but I believe that it's my role in here to test and to push and to ask these questions. And so I just want to make one minor clarification with respect to the $6 million per year in the core for language. The minister quite rightly talked about the impact that the investments that this government has made into Indigenous languages. And to that, it's one of the key aspects of colonization was the removal of language, the removal of culture through language. The minister suggested that it was the parents and the grandparents that were teaching the children the language. And I would like to say in my family, it's the child that's teaching the parent and the grandparent language, which I think is, to some extent, an indication of the success of this program, because it's being taught in the Husseinich school at Tlaimung School. My daughter Ella is in a language nest program, in an immersion program, and oftentimes if I have to say something in the legislature and I don't know that if I got it quite right, I'll text her and ask her, what is it that I should be saying here, kid, and I'll get it back. And for my late uncle Tomasingtat's eulogy, I had some Senchothan language that I needed to get clarified. I got it clarified with Ella, and then I asked it of one of my elders, and he said, well, she got it right on, she nailed it. And so there is a wonderful story that's being told here, Minister, about those language investments, and I think that it is important to acknowledge it. I think in the spirit of how the minister has framed the budget for the Ministry of Indigenous Relations and Reconciliation, the provincial responsibility to deal with the colonization, to create partnerships, to support the advancement of reconciliation, I want to start by asking some questions just around a question that I asked a different minister during question period last week. I asked the Minister of Public Safety and the Solicitor General about the provincial funding of the Community Industry Response Group, CIRG, as it's known. It's an elite RCMP unit designed in part, the work that it's been doing is to clear Indigenous land offenders or removing them from their own territories. The Minister of Public Safety did, as he's done in the past, he referenced the rule of law. He noted the RCMP have a responsibility to enforce a legal injunction. And of course, this is a blurring of some confusing and complex legal lines, really. While the minister seeks refuge in the reality that corporations have sought civil injunctions to protect their interests, and that this government's militarized police unit, the CIRG, is dealing with the resistance to industrial development, the minister ignores that there's a remarkable difference between corporate interests and Indigenous rights. The Indigenous rights that it's at the core of the provincial responsibility that the minister's budget is being used to address. Arthur Manuel called the use of injunctions against Indigenous people in their own territory, quote, legal billy club, end quote. A study in October 2019, Landback, a Yellowhead Institute red paper by the Yellowhead Institute at Toronto Metropolitan University, looked at 100 injunctions and found that 76% of the injunctions filed against First Nations by corporations were granted. While First Nations were successful against corporations, only 19% of the time. What this tells us is that the courts continue to prioritize the economic harm to corporations of lost profits over the economic harm to Indigenous peoples of devastated livelihoods. I think one of the clear examples of this is in both the Trans Mountain and the CGL, the Coastal GasLink pipelines, with respect to salmon. This is really a reference to the irreparable harm and balance of convenience tests that are used to require and obtain, required to obtain an injunction. Through you, Madam Chair, to the Minister, is it in the Minister's mind, what takes precedence, corporate interests or Indigenous rights?
Minister.
Thank you very much. And I want to start at the outset by thanking my colleague from Saanich North and the Islands. I totally respect the tough questions that is his duty to ask, and I appreciate just as well the very supportive things and his constant support for the work of this ministry in trying to make a difference in Indigenous people's lives. I salute that and acknowledge that at the outset. I also want to say to Ella, how proud you must be. I had the similar circumstance arise. I can remember down in the Hall of Honor, we had a day, Indigenous Languages Day, and a young woman, I don't know, she might have been 17, stood up and gave this remarkable speech in Hulkaminam. And it was just so moving for me to see that. I've seen, of course, elders speak at length in their language, but it's equally, if not more impressive when you see a young person do that. And it's a tribute to the work of so many elders and so many communities who see the importance of this and who don't want their culture to disappear, to their languages to become extinct, as they're frankly on the verge of being in some parts of our province. And it's really exhilarating to see that. And it gives me great personal pride, not to blow the horn of our Chief Executive Officer, Tracy Herbert, from the First Peoples Cultural Council, to go back to Ottawa and have people like Minister Rodriguez, the Federal Minister of Heritage, who's responsible for the Indigenous Languages Program, to just, without prompting, sing the praises of the pioneering work of RBC Crown Corporation, the only Indigenous-led Crown Corporation in, I think, the country. And it's just exhilarating to see, and it's something British Columbians should be very, very proud of. So I just want to thank you for thank the member through you for that recognition. The second part of the member's question related to, firstly, the community industry response group and the rule of law, in particular talking about the role of injunctions. And I think thoughtfully drawing a distinction between criminal and civil injunctions, and perhaps a report that the Yellowhead Institute, which I've also read, talks about the differential between those injunctions successfully sought by one group and less successfully by another. Of course, we all know that the injunctions are granted at the behest of a corporation or of an Indigenous group or of someone in the community, applying the test that the member talked about, the irreparable harm balance of convenience test, which is the law on injunctions. But of course, the fundamental point is the decision-making is for an independent judiciary. And it's not, I think, germane for me to give my views on how those rights are prioritized. It's a court that has to make that determination. We have an independent court system, and as in all actions involving police, which was the threshold question about this community and industry response group, threshold question, of course, involves the role of a government and a police service, and then ultimately the courts. And of course, we would all accept that it's not the government that directs the police how to do their work, and it certainly isn't our role to tell governments, tell an independent judiciary how it should weigh the interests that are always at issue in this irreparable harm versus a balance of convenience test.
Member.
Yeah, thank you, Madam Chair. And to be clear, I'm not asking the minister to instruct police. I'm not asking the minister to instruct the courts. The minister is responsible for the implementation of the Declaration Act. the relationship with Indigenous peoples, the Declaration on the Rights of Indigenous Peoples Act. And when we have legal work, an analysis done that shows very clearly that the tests that are used to obtain injunctions are so heavily favoring industry over Indigenous rights, in some cases Indigenous treaty rights, the rights that we protected. The questions that I'm asking are not for the minister to direct the court or to direct the police, but as the person in our government who's responsible for and who has the budget that we're debating today for ensuring that Indigenous people can get the justice that they need for their inherent rights that have existed on the landscape long before the corporation was even considered. What I'm seeking is to whether or not the minister sees the pattern that was illuminated by the red paper and maybe has comment about whether or not this demonstrates that the current laws and actually the practices with how injunctions are sought is not consistent with the Declaration and the commitments that we've made to Indigenous people.
Minister.
Madam Chair, the tests used for injunctions that the member refers to are the tests that have been used in civil cases, from trade union context to confrontation in various places, including, of course, Indigenous rights and title cases that come forward. The member refers to a study which I also had the benefit of reading. I'm not in a position to evaluate the conclusions that that study reaches. I found it intriguing, I must confess, disturbing, but again, it's a social science research. I've learned it often depends on who's doing the research and what questions they ask, and it may not always be the world may not always be as clear as researchers trying to make a point would make. I'm not here to malign the report. It could be excellent, but I just would rather not comment on the merits of a report. I don't know the methodology that led to that result. Our ministry isn't, of course, responsible for the budget of the police, but what our ministry is responsible for, and under the Declaration Act that the member referred to, is trying to achieve unity amongst nations, trying to avoid some of the conflicts as well that existed. And the one that the member alluded to with one pipeline conflict involved some of the hereditary chiefs in Wet'suwet'en territory, and we have invested considerably in trying to create unity within that community to implement so that Wet'suwet'en title, which we accept to exist on the land, can be implemented in an effective way. And that, of course, is all about governance. It's all about ensuring that the resources are there to take on the responsibility of governance. And that is where we think we can make the best contribution. We would want to avoid the conflicts that the member alludes to, because we think a better path is always through negotiation and resolution informally of those disputes.
Member.
Thank you. And I thank the minister for his response. I think where we are, and I recognize the challenge of alluding to a study, and we're only one step better because the minister's actually read the study. So we could have been in a much worse situation if the minister said, well, I've never seen the study. So at least the minister has read the study, and I appreciate that. I think I used the example in the study because it reflects what the experience of Indigenous people, some Indigenous people at least, is on when they interact with the legal instruments that are available for all of the public to use. The public interest, interesting, I ran into the public interest through the TMX. I was an intervener in that. They had no interest. There was no desire to consider my fishing rights. It was talk about convenience and interests and the language, the public interest. I was definitely, and the intervention that I made on behalf of the TMX was at the front end of the process. It wasn't at the legal end as they're standing in front of the pipeline. I intervened because I wanted to be a part of the process at the beginning. But I can tell you, there was no desire to consider the fishing rights of the Wet'suwet'en people as part of the broader Canadian public interest. And this is the point that I'm making, is that Indigenous people, and it's the point that Arthur Manuel made, it's the point that the authors of this study make, is that Indigenous rights and Indigenous people are inconvenient when they're not signing the agreements, but when they're standing up for their rights. And that's the way that, at the very least, if you just take the social science study on its for face value, and you see those statistics being so heavily weighted towards recognizing that if a corporation, we saw this with the injunctions that happened at Ferry Creek, the fact that the corporation could lose money and could lose standing was the thing that was more important than anything else. That's the public interest that is being protected, the status quo. And up until very recently, up until 2019 when we passed the Declaration Act, Indigenous people were clearly outside the public interest. When I intervened in the TMX, we were, and in fact I complained to the panel, are viewed as outside the public interest. Would the minister agree that the requirement that these injunctions are based on, the rules that we create, the laws that we create in this place, are what the courts have to go on? Ultimately, we don't direct the courts in their decisions, but we create the statutes with which the courts make their decisions through. Does the minister agree that the public interest requirement in injunctions is biased against Indigenous people, First Nations people?
Minister.
Thank you very much. I wish my colleague, the Attorney General, were here, because I think many of the things that the member has asked about, really significant issues, are in the purview of that ministry. I want to say, though, I think education, I've always said, is one of the key things that we have to address. I was talking to Kim Baird, who is a former chief of the Tsawwassen First Nation, and she told me that she's doing really work that seems to be very well respected within this House, the Legislative Assembly of British Columbia, from the dining room staff to the clerk to the Speaker's office, to ensure that this legislative branch of government understands the history, the culture of Indigenous people, and the struggles and the injustices. I have the opportunity to speak to the judicial justices, I think they're called, what we used to call justices of the peace, in a couple of weeks. And they've asked me to come and talk about the work of reconciliation. But I do so with great respect for the fact that they are an independent branch of government. In terms of the judiciary, I think the member would agree with me that some of the great advances that have been achieved by Indigenous peoples in pouring meaning into the words Aboriginal rights and title in Section 35 of the Constitution Act 1982 come from the courts. The courts have made enormous strides in pouring meaning into those words of the Constitution. There must be thousands of cases, literally, where those words have been given meaning. And so I think the judiciary gets it. I think the judiciary is on a path, like the rest of us are, to try to understand better the difficulties of reconciliation, and that applies to the tests that court use just as it applies to the laws that we interpret. The member's right. Some of the things that judges grapple with are statutes that are created in this House. But some of the tests that they're applying, like the one he's alluding to, are common law tests that have been around, nuanced perhaps, forever. And whether those tests will be evolved by the courts, as they've evolved so many other things to better address the balance that the member refers to, the rights of Indigenous people as against corporate interest, as against the community's interest, those, I think, are things that the courts, as an independent institution, are going to evolve. But I go back to where I started. Education is going to be the key. I'm proud of the work our government has done to educate the public service on Indigenous rights. And I think that this institution, the legislature, deserves credit for its efforts to step into that difficult conversation that needs to take place. And I'm really confident that the judiciary will rise to the same challenge.
Member.
Thank you, Madam Chair, and thank you to the Minister for the response. And indeed, the exercise that I believe that I'm engaging in here today is exactly that. It's exactly in the spirit of education. I am definitely going to be raising some of these issues with the Attorney General. I'll be raising them with the Minister of Public Safety and Solicitor General as well. And as the Minister knows, following my question, we had a conversation because I believe actually that This institution has done things in a way for a long time. Our judiciary has done it in a way for a long time. And these systems, we know, were not set up to be inclusive. In fact, they were set up in their design. The Indian Act, for example, the federal legislation, was designed to undo everything that we were talking about earlier in the languages, is now putting back together again. So, you know, I think part of the reason why I'm raising this issue here and why I'm going to continue to raise this issue is because when I asked the question about, you know, a specific police action in a part of our province to another minister, and the response comes back to say, well, this is about the rule of law, the point that I want to make is that it's more nuanced than that. And to lead the people of British Columbia to believe that it's less nuanced or that it's more simple than it actually is actually counter to the to the comment that the minister just made with respect to education. We are being less informative if what we're doing is, if we're reducing this to simplicities. Because it's not simple. What's going on the landscape, the Trans Mountain Pipeline, the fishing rights that comes with the name Sahanup, the locations the swalets that are existing there, none of that's easy. None of it should be seen as a simple struggle. It's a challenging one, and that's part of the reason why I'm going to taking the time here to just say that there's an aspect of this that has to do with the declaration and our journey of reconciliation. And that's the part that I'm kind of laying at the feet of the minister. I'm not laying the part that's for the Attorney General or the part that's for the Solicitor General at the feet of the Minister of Indigenous Relations, although I think the minister's relationship with his colleagues can assist in working towards making, you know, we saw some changes through some judicial orders with respect to the teams for violent and repeat offenders. We see that the government of BC doesn't have, we see that the government of BC has tools at their disposal, and what I'm imploring the government of BC to do is use them where appropriate. Of course, we don't want to be directing police, and there's independence in these, but we also have a role in making sure that these systems are working for all British Columbians, and they have not been designed for all British Columbians. And this is the journey that we're on together. I'm going to move on to a different topic, so if the minister has a comment to this, I'll leave it to the minister. Otherwise, I can move on to another topic.
Minister.
Before I make a comment, and wanted to ask your indulgence to welcome to the chamber Chief Willie Sellers from the Williams Lake First Nation. I'd like to make him welcome here as he observes this debate on our estimates. He's, of course, a remarkable community leader in his, not only in the Williams Lake area, but throughout the region. And he certainly prioritizes economic development for the benefit of his people, but for the entire region. He's a real role model for me. I understand as well that we have Courtney Cook, who is the CAO, Chief Administrative Officer, and Kirk Dressler, who is the Director of Legal and Corporate Services. I met them earlier today. I'm so pleased they could join us. I just want to say to the member, that with I remember vividly the day in which the debate he refers to took place in the legislature. And I just wanted to say, I think he'll agree with me that sometimes the question period may not be the most, to use his word, nuanced environment in which to have the dialogue that he seeks. Sometimes I've seen some members, maybe even me, reduce things to simplicity, or even slogans sometimes occur in question period, which is not conducive to the kind of thoughtful dialogue that the member seeks and is seeking in through the estimates process to do. So I respect that, but I think he would agree with me that sometimes the forum isn't conducive to that kind of dialogue.
Member.
Actually, if I may just correct the minister, or ever conducive to that kind of dialogue at all. Actually, I wouldn't call it dialogue. Thank you, and thank you for indulging me on this. And I'll just leave it to that, and I'll continue the work to raise these issues with respect to the enforcement of injunctions and the relationship between resource extraction, resource development, and Indigenous rights. I want to move to cumulative impacts. This is something that has been obviously a growing area of discussion. The Yahe case was remarkable because for the first time in the BC Supreme Court found that the cumulative impacts of development approved by the provincial government, slicing and dicing territories into ever smaller fragments, infringed on the Blueberry River First Nations Treaty 8 rights. As Mandel Pinder described on their website, quote, "For the first time, a court has found that 1, a province breached treaty promises by permitting the cumulative impacts of industrial development on treaty rights, and 2, infringed a treaty by taking up lands to such an extent that there are insufficient lands for the meaningful exercise of treaty rights," end quote. The provincial government did not appeal this decision to the Supreme Court of Canada and negotiated a settlement with the Blueberry River First Nation. Virtually all aspects of the Yahe decision can be applied to Husaitnich, the territory that I'm from. The treaty text, the provincial permitting processes, the provincial belief that the treaty gave them the right to take up all the land, even to the point of there being no land left to undertake treaty-protected rights, and the ever-frustrating circular arguments, as the court called it, the, quote, "persistent pattern of redirection," end quote. That continues even after the Yahe decision. One quick example, with respect to the Bamberton Quarry project in the Saanich Inlet in the Husaitnich territory, according to the Environment Minister, we don't need to worry about the environment because the regulation of mining in the Mines Ministry is good enough. However, the Mines Ministry will refer you to the Environment Ministry because they regulate and enforce environmental protection. Round and round and round we go on that. When we look at aerial photographs of the Husaitnich territory, there is no other conclusion than that the rights protected by the Douglas Treaty, of which I am a member, the same language as Treaty 8, the right to fish is formerly, and specific hunting rights that have been challenged and successfully defended in the BC Supreme Court, the Canadian Supreme Court, have been breached by the province by permitting the cumulative impacts of residential, commercial, and industrial development. And the Douglas Treaty rights have been infringed because the province has taken up lands to such an extent that there are insufficient lands for meaningful exercise of treaty rights. The entire territory has been divided and subdivided and sold fee simple to private property owners. It is entirely an urbanized territory. The federal government divided our governance into councils that served their purpose, creating governing bodies that have no reflection of our traditional governing bodies. There are no trees for us to log, no fish for us to catch, no gas for us to frack, no coal for us to mine. There is, however, potential produce for us to grow, a faint light in the tunnel. The economy in our territory is real estate. That's it. The ministry is working to develop a new fiscal framework with Indigenous nations. It will largely be focused on natural resource development, as we heard at the beginning introduction comments by the minister. There is no forest industry for Husaitnich to partner with, and that was, as the minister stated, where the new fiscal framework begins. So through you, Madam Chair, to the minister, what's the plan for Husaitnich?
Minister.
Very much, and thank you to the member for the question on cumulative impacts, how it applies in the Saanich territory, as well as, of course, up in the northeast where the Yahe decision he refers to was decided. I'd like to start by saying that I could not be prouder of our team at MUR and a team government, if I can call it that, from all the ministries who spent 18 months doing what many people in this House told us we ought not to do. Many people told us we should just appeal and get on with it. And we said, no, we're going to sit down and we're going to negotiate a just resolution, because the court, as the member properly pointed out, found that we had breached Treaty Number 8, historic treaty from the turn of the century, that is to say the 19th to 20th century, and that we had provided insufficient lands for the exercise of treaty rights. That's what the court said after a, I don't know, how many 100-page decision. And we said, We've got to figure out how to do this together. We've got to figure out, we've got to sit down, we've got to negotiate, we've got to figure out how we can heal the land, how we can find better planning mechanisms in the future for First Nations to feel that their lands, their rights are at the center of decision-making. We've got to find ways to revenue share. We've got to find ways to find a better balance and alignment of values. That isn't easy work. That was extraordinarily difficult work. Our team was very much involved in that work, but I would be remiss if I didn't praise the talented officials from other ministries, Energy and Mines, Low Carbon Innovation, Environment Ministry, and so many others that got us to this place. We settled that lawsuit, and I'm so proud of it. Not just with the litigant, the Blueberry River First Nation, with former Chief Yahe, but with other Treaty 8 nations. And we are on a path to a much better place to deal with cumulative impacts. And those cumulative impacts, the members properly acknowledged, aren't limited to one part of our province. They're a fact in many, many parts of our province, and has to do with colonization, it has to do with industrial growth, it has to do with population demands, and we do need to acknowledge that in doing so, there are Indigenous rights, First Nations people who live there, and Aboriginal rights and title that are involved in the case of the members of Douglas Treaty, but areas where there are no treaties and where those rights are still at the fore. So we have work to do, and it's difficult work, and it's work that we're rolling up our sleeves to do, we'll continue to do. He gave a specific illustration as well about a conflict that's currently at the fore, which is relating to the quarry at Bamberton and the expansion sought by the Malahat Nation, a nation that is seeking to enter into treaty. And other nations in the territory are opposed to that expansion. That nation, the Malahat Nation, sees it as part of its economic future. It is my colleague, the Minister of Environment, that has to look at whether this project should be reviewed under the Environmental Assessment Act. And I think I should say no more than that, because he is the statutory decision maker. It's under his purview that that decision will ultimately be made.
Member.
Thank you. And I'm now sorry that I even referenced the circular wash and rinse cycle that Indigenous people find themselves in when they engage this government sometimes. And I just used the example of the endless cycle between mines and environment about who's going to protect the environment. And I recognize I might have distracted now from the actual point of my question, which was the cumulative impacts of commercial, residential, and industrial development that has entirely suffocated the rights of the Husainich people to, and infringed and breached, and all of the language that the courts used for Yahe, the Husainich people, as a result of this government's, provincial government's decisions. I can't harvest clams in my territory because our beaches are perpetually closed. I can't harvest salmon in our territories because our fishing areas are virtually empty, and when there are fish, it's illegal. If I chose to fish in those times when there were closures, then I'd be criticized for that. We can't hunt any longer because there are no enclosed fields and there are no areas for us to hunt. We are in exactly the same, and in fact, I would argue, and this is not about saying our situation is worse, but I would say that in a very similar, very real situation to what Yahe is facing, the Husainich people and the other Douglas Treaty nations here that James Douglas signed those treaties with, or went into an agreement with, I should say, are facing an exact same situation. One of the ways that this provincial government exerts its sovereignty is through the taxation of land ownership. There are many real estate transactions that exist and happen every year in our territory. Before I ask my question, I think I need to be very clear. I'm not suggesting the increase in land taxes for my constituents, okay? And the deep fakes are going to be all over this. Nor am I suggesting that there be any threat to fee simple land ownership, okay? That's not what I'm suggesting with this question, so I want to just insulate my question from anybody who might want to take it there. What I am asking about is whether or not this minister, the Minister of Finance, previous ministers, the ministry ever considered sharing a portion of the property transfer tax and the speculation and vacancy tax with the Husaitnich people in recognition that the resource that's extracted from the land in Husaitnich is no longer fish and clams and deer, which was the form, which was, and many other products which formed our economy. It is now real estate transactions, and it feels to me that this is an elegant, and if not far too simplistic solution for the very real dilemma that this provincial government faces in the reality that we did accept the Supreme Court of BC's decision in Yahe.
Minister.
Very much, and I'll just reinforce what my colleague didn't say. He did not say in his questions that this was about raising property taxes. He did not say this was intended to be a reflection of the need to address fee simple. So lest there be any doubt, I want to reinforce that he did not, what he did not say, because I know he would be adamant if I didn't do justice to that in his question, because it was a much more thoughtful question. It was about how the new fiscal framework that we're trying to elaborate could apply in the territory that he comes from, in the peninsula. But I think it's fair to say we are trying to elaborate a whole bunch of changes across the province. Now, the current focus of our new fiscal framework is on forestry, and there's a very good reason for that. The member has been advocating very effectively for the what our government inherited, a very atrophied revenue sharing under what are so-called FCURSs, and the member has done a lot to educate me on the injustice of that, and we have, as an interim step along the way to a new fiscal framework, we have made some significant strides. I think most people would acknowledge that generally the revenues that are shared are double, sometimes more, sometimes a little less, but about that usually across the province. But that's only an interim step, and we always said it was only an interim step. And so what we are doing is going across the province. We've had I think 91 meetings or so with First Nations and rights and title holders, as well as Indigenous leadership groups, trying to understand what a new fiscal framework would mean to them beyond forestry. And I would bring to the members' attention two key aspects of our action plan. Action number 1.4, which says we will co-develop with Indigenous peoples a new distinctions-based fiscal relationship and framework that supports the operation of Indigenous governments, whether through modern treaties, self-government agreements, or advancing the right to self-government through other mechanisms. This work will include collaboration with the Government of Canada. And secondly, action plan item, action number 1.5, which I think is very germane. We will co-develop and implement new distinctions-based policy frameworks for resource revenue sharing and other fiscal mechanisms with Indigenous peoples. We are doing that important work now, and we've heard a clear message of change from the work that we've done so far, that new fiscal framework must support a fundamental shift in the way we work together as governments and support an integrated, rights-based approach to decision-making, stewardship, and benefits sharing. So when the member refers to the main industry, perhaps in his area, I don't mean to caricature it, but involving property, certainly not involving hunting or forestry anymore. I know his community well, so I would agree it's not that. We recognize that we have to be nimble, and we have to recognize that the fiscal relationships in one part of the province are not those in another part of the province. We have started with forestry because it means so much to so many, but we acknowledge that work is going to have to be more flexible to deal with the realities of an urbanized environment or suburban environment, and that is the work that we're doing.
Member.
Thank you, and thank you to the minister for his response and for further adding clarity. I'll just say that there is, if the minister is advancing this idea that I know is not been entirely a foreign idea, it's one that The one around the property transfer tax and the speculation and vacancy tax is one that I advanced with former finance ministers and with others. If there's any need for a justification for it, if the minister ever needs a justification for it, I think that it's important to acknowledge to the Minister of Finance and to those around the Treasury board table that the reality of this is going to be, I think, largely seen by the province as a loss to the province general revenue. But I encourage the minister, I encourage the Minister of Finance and this government to view this as a benefit. Because the reality of it is that that money, and I have lived in Satanich my entire life, we love that place, we're not going anywhere, and we're going to invest immediately into our home. That's what we do. When COVID hit, we bought food for the people. We fed the people. That is the inclination of our leaders. That is the teachings of our culture. And so when you apply that to increased access to revenue, what ends up happening is that the Satanich people become valuable investors into the region and into the area. And I can assure the minister, I can assure the finance minister that that money will be immediately reinvested right back into the community and the provincial government in all the ways that the provincial government generates revenue from those activities. They will see the benefit of that immediately. And so this need not be viewed as a loss to the provincial government. This is simply an interim step that allows for the Satanich people to fully realize their inherent and their treaty rights to self-determination, to be economically engaged in their territories and not kept off to the side, not to be those people over there on the other side of the ditch, but to be investing in their communities with the resources to be able to do it. And I really see the fiscal framework. When I heard that this announcement was happening, I was elated, or this project is happening, because really the Declaration Act was the first step. It was the policy area. But in order for Indigenous people to be really, truly, fully engaged in this journey of reconciliation, we need the resources. I brought it up in the supplemental budget estimates. We need the resources to be able to meet the government where the provincial government and the federal government where they're at. And we don't. We show up to meetings. The minister responded to all of the different ministries that were involved in getting the Yahe case settled. Only people that were failed to be mentioned in that list were the handful of people on the other side of the table that were meeting the ministries at the table. And you know, it's interesting that when Indigenous leaders sit at the table, there's always dozens of government people on the other side of the table, and there's just a couple of the technical people sitting there going, oh my goodness, how am I going to deal with this now, right? So, and I know I don't want to make any assumptions that the minister was not, or make any statements leading to anybody to conclude that the minister wasn't grateful for the Blueberry people on the other side. That's not what I'm saying here. But what I'm saying is that we need to be able to have the resources to meet the government where it's at so that we can be effective partners, so that 30 days time, so that we're not complaining about 30-day timelines for notifications, because 30 days is long enough because we've got a robust internal and administrative capacity to meet the government where it's at. That's exciting to me, and that is what I see the potential of this. What we need to do is move it past the simple resource agreements, because there's not trees everywhere. There's not gas everywhere. There's not coal everywhere. There's not the resource extraction everywhere. And in some places, there are these resources that we don't really view as resources, but they are. And in this case, the property transfer tax is a huge resource that's generated on our land every single day. And in order for Satanich people to be able to realize their sovereignty, there should be access to that. I'm just going to end with this, and then I'm going to turn it over to my colleague from Vancouver-Langara. This is just around, I'm just going to shift gears here, Minister, to the use of the Aboriginal Affairs Committee. I've written a letter, and I just want to leave my time and budget estimates here to implore the government once again to please use the Aboriginal Affairs Committee for what it could be very useful for, and that is the high-level policy discussions that ensures that our government, when we are meeting with Indigenous nations, are truly able to meet in as little a fractured way as we possibly can. And I think that that's the benefit of that committee work. And I think we saw an example with the Tsawwassen Treaty, letters flying back and forth, committee used, not committee. We're going to meet in the Douglas Fir. We're not going to meet in the Douglas Fir. We're going to have, we did meet in the Douglas Fir, then we had the chief there, and then budget estimate starts back up again while the leadership is in the room. It was frankly something that we could have avoided had the minister, who has the right to make these decisions about policy, brought his colleagues from the opposition into that decision, had that discussion. We could have had the discussion with the nations that have treaties. We could have had the discussion with them in this room and at the committee stage. And then when we have guests in our house, as we're always taught in our longhouses, you act as a family, a strong family, and that's the way that you demonstrate that you're a good partner. And I really felt that we didn't act as a good partner, or it didn't end up that way. I think we were trying to, but it didn't end up that way. And I really think that the use of the Aboriginal Affairs Committee for high-level policy discussions that can build consensus across party lines, recognizing that no matter what, there is always going to be another government, and no matter what, we can never predict who that government is going to be. Indigenous people, Indigenous leaders need to know that when they're approaching this government, no matter who is in the premier's seat, that they can count on us to be reliable, mature, and that they can count on us to be consistent, even if there is fractures. And I think the committee gives us that opportunity. Will we be using the committee more appropriately in the future?
Minister.
And there were 2 or 3 important points made by the member. First, I just want to acknowledge and agree with him that when these new fiscal arrangements are finalized, be they in forestry or mining or other economic measures, such as the ones the member has suggested we include, involving taxation of lands, that money often, if not always, gets reinvested in the communities affected. I think that's exactly what is happening in the Northeast. It's what's happening in the Northwest in Tahltan territory. It's happening for sure up in the Fort St. John, Dawson Creek area with the revenues that are being generated now. So the member is not only right, there's empirical evidence for him being right about that, and we agree. I think it's also fair, as the Premier said, that our government knows that First Nation governments have responsibility and authority and jurisdictions for their land and their people. And as a government, as a First Nations government, they need resources to be able to do that work. And that's what I think the member is bringing to our attention. And we are developing a process for that work. We accept that that's an important part of the responsibility if they are to have the ability to effectively work with us as they have been seeking and as the member has advocated. The other final question the member raises concerns the application of the standing committee. And I start by saying that there's no, many of us have said, there's no sort of premium on good ideas. They don't come from any one side of the House. And so to take advantage, I'm certainly open to exploring the ideas that the member talked about. And I think that work with the House Leader's help is something that ought to be talked about. We do have a standing committee, but I think the member's point is it hasn't been utilized to the degree that it could be. And I accept that progress on reconciliation is a shared responsibility. It's not just this government, it's all of the legislature that stood up in November of 2019 and enacted the Declaration of the Rights of Indigenous Peoples Act, and I never give a speech anywhere where I don't make that fundamental point, that this is not a partisan issue. This is not one party. It's all parties that joined hands around that sea change in our relationship, and I accept that. And I think, therefore, we as a legislature we've got to utilize the tools that are available. The member makes a reference to one tool. There are many others, but I do think the fundamental point he makes has to be underscored. Namely, we all have a job to do. We all have a commitment and a duty to reconciliation.